Hello and a very good afternoon to all of you who are watching us from the East Coast. My name is Neha Mahajan and I'm the Business Development and Outreach Manager here at Chug LLP, attorneys and CPAs. And a very good morning to all of those who are joining us from the Pacific time zone, from the West Coast. A very good morning to you too. So, before I dive into our topic, which is I am very sure of interest to a lot of you because we are going to be talking about interfiling. Before we go into that topic, I'd like to introduce our speaker for today, our guest for today. That's our partner and attorney, Dia Matthews from our New Jersey office. Hi there, Dia.
Thanks, Neha. Glad to be here.
Right. Yes, absolutely. Now, Dia, there have been some recent updates by USCIS. There's this one particular one that we want to talk about. That's interfiling. I'm sure you're getting a lot of calls about this whole interfiling thing ever since it was, this guidance came out by USCIS. So we're going to dive into it. But I'll just give a little bit of a background about what this interfile, why we're talking about this topic today, right? There has been a lot of movement in the employment-based green card category, especially the EB-3 category since October of 2020. And it's been beneficial for those who are under the backlogged category, as we call those who were born in India, right? And what has happened is a lot of people, because the dates got current at that point in time, those who were in EB-2 category, they downgraded to EB-3 category. And we didn't know at that point in time how long it's going to take, whether USCIS is ready for this influx. And there were a lot of unknown back then. But we now know that there are still a lot of people where we're sitting here. Today is February 3rd, 2022. This time era that I'm talking to you about is October of 2020, right? There's still a lot of people who haven't yet had their green cards. And now there is this new guidelines by USCIS on interfiling. So, Dia, for everybody's benefit, what does interfiling actually mean? What is interfiling?
Right. And you put it very nicely, Neha, this whole background, right? Because in 2020, October 2020, the big news was that you had the option of downgrading because EB-3 was moving very quickly. And so everybody jumped into the EB-3 boat, right? And then, of course, we would have questions from clients, is EB-3 going to be faster? Is it going to remain faster? Or should we expect that EB-2 will move faster because everybody is now moving into the EB-3 queue? And I think as predicted, that's what happened, right? So now we have this update from USCIS. And USCIS manages to keep our lives interesting one way or the other every month. And I think this interfiling, they call it the transfer of the basis. This was the big news for this year. Came out towards the end of Jan, I think the 21st of January. And they said basically that they have more visas available to give out in the EB-2 and the EB-1 category. So if there is an option for somebody to, to use that category, then they would prefer that they put in a request. So this is for people who already have an I-140, an employment-based immigrant visa petition already approved in EB-2 or EB-1 or pending. So if that's the case, and you happen to also have an adjustment application already pending with USCIS based on the EB-3 that you might have filed earlier, then you are basically going back and asking USCIS to connect the two. So connect the EB-2 or the EB-1, as the case might be, with the existing, with the current 485 petition, which is based on the EB-3. And so this is a way for USCIS to, to streamline the process and connect the two and then file your application in EB-2.
Yeah. So, Dia, so this latest update that we have, right? So does it make everybody who downgraded in EB-3 makes them eligible? Is that what it is?
So the interfile, right? The interfile makes sense if your EB-2 date is current according to Table A. Okay. So a lot of people who filed in October, November 2020, they were downgrades, right? Because they already had approved EB-2s, but they chose to downgrade because EB-3 was faster and then they filed. So now when you're going back and asking USCIS to approve your case based on the EB-2, the one thing you have to check is make sure that your EB-2 priority date is current according to Table A. which is the the visa bulletin now has 2 charts, right, to make things even more interesting. Now there's 2 charts. One is table A, the final action dates chart, and then there is table B, which is the dates for filing chart. So you cannot request, it doesn't make sense to request an interfile unless your EB-2 priority date is current according to table A, the final action dates. If that's the case, then it makes sense to put in the request.
Okay, so not everybody. It's only if your, if your priority date is current under the final action date. It's only then that you can interfile, right? Yeah,
Yes.
we're going to be talking about this whole interfiling. It's a lot to take in. It's sounds very complex. Probably is not that complex, but you need to know what the right way of doing things is, and that's why we go live every Thursday, 11 a.m. Pacific time, 2 o'clock. Eastern time with our attorney or CPAs, and we pick up one topic each week and we talk about it. And just to give you a disclaimer, this discussion that we are having today is in no way an attorney or client relationship. It doesn't establish any of that. This is just for informational purposes, all right? And we are live on Facebook, LinkedIn, and YouTube. And if you have any questions for us, just feel free to put it in the comment section. And if we have time, and we'd be happy to help you, answer those questions live right here. So Dia, how common is it for people to downgrade and interfile? I don't think I had not heard of these terms before October 2020.
So interfile is actually not a new concept, right? It's always been there. Historically, we would do it when, I think the common scenario that we would request an interfile is if somebody was in the India queue, right, the India backlog, and they had an adjustment application pending based on an EB-2 or an EB-3. And then let's say they got married to a US citizen, right? And then, so based on the marriage to a US citizen, they would be eligible for immediate visa issuance as a spouse of as a US citizen. So in that case, instead of filing a 485 again, what you would do is you would file a marriage-based I-130 petition, and then you would ask USCIS to connect that I-130 with the pending 485 application. So that was usually the situation in which we would request an interfile in the past. And there was no methodology. There was no specific process for it. It was, I think the understanding was that USCIS, DHS is doing it more as a courtesy. So you would write to them, you would call them, and sometimes, there was no saying how long this whole process of interfiling or connecting the 2 files would take. It just depended on your luck and whether you got a nice officer or not.
Yeah.
So the good thing is now they've come out with this guidance. And, really they should have done this earlier, right? Because we knew from about, towards the end of 2021, we saw that EB-2 was starting to move faster again. So a lot of clients would ask, okay, should we refile the 485, right? We already have a 485 based on our EB-3, but we don't mind refiling the adjustment applications to benefit from the EB-2, because the EB-2 is now moving faster. And I think most practitioners grappled with this. We would tell our clients, okay, you can refile if you want, but USCIS doesn't really appreciate the paperwork, because each time you file a new 485, you're putting in a new application and they have to adjudicate it. They have to start from scratch again. But I think it's just that, so many people are desperate. They have been waiting years, right? 12, 14, 15 years. And at this point, if it's just refiling a new 485 application, they don't mind doing it. It's expensive. You're paying for the filing fee, the attorney fee, medicals, all of that again. But many people are willing to do that. But everybody knew it was just like a bad, way of, it was not a very efficient way of doing it, right? As it is, we know USCIS is very backlogged, and the pandemic has, added to their, challenges. So now, you're encouraging people to file 485s again. So we knew that was not the best way. We gave clients the option of asking for the interfile or for refiling the 485, right? That was because there was no guidance from USCIS for a long time. So finally, in Jan of this year, they came out with this guidance saying, okay, interfiling is the preferred approach. And so that's what everybody should be doing now. If they have eligibility for EB-2, then put in the interfile request.
Okay, so that's definitely some good news for people who've been waiting, because as we know it, a lot of people are concerned about what happened to their applications, because you don't really get a receipt notice or anything after you've submitted your 485. You really just wait for that adjustment of status to happen, right? If I'm right there, Dia.
So with the 485 application, you do get the receipts, although the receipts take some time. Right, you get the 485 receipt, and typically if you put in the advanced parole and the EAD applications as well, you get the receipts for those as well. With the interfile earlier, it was just a paper request, right? So then you wouldn't know. But now with the guidance that USCIS has put out, they have said that along with the interfile request, they are expecting a 485J. So the 485J in the context of employment-based applications is basically a confirmation from the employer that the position is still available, that the job is still available. So when you put in the 485J with the interfile request, you do get a receipt. It takes some time, but at least you have some proof that your interfile has been receipted. Yeah.
Right. So one question that comes to me all the time is, how many times can an applicant downgrade and then interfile? Won't this cause confusion at USCIS? And are there any chances of rejection, or will the chances of rejection become high?
I would assume that somebody is not going to be doing this too often. Interfile works in the situation where you already have a 485 application, an adjustment application already pending, and you're merely asking USCIS to approve that 485 based on an I-140 petition, which is current at the moment, right? Mm-hmm. So maybe you had an EB-3, which was current, now an EB-2, but I don't anticipate too much of this, going back and forth. So USCIS, the guidance to USCIS, or, what they're supposed to do is approve the 485 based on the I-140, which is most advantageous to the applicant. So once they know that you have these I-140s, they are supposed to pick out the one which is most advantageous to the applicant and approve the 485 based on that. So let's hope they.
Yeah, no. And, thank you for explaining that, Dia. I would like you to go a little bit in detail about the process of interfiling as such. Also, I would want to ask you, does one really need an attorney for this, or can people just, say, send a letter to USCIS or call up USCIS and say, hey, our dates are current and we'd like to file it? We'd like to interfile?
Yeah, I think there's always value add in having a professional represent you. And, on the face of it, the process is fairly simple in the sense, you put in the written request. Right. In the 485, you enclose the copies of the 485 receipt notices and the I-140, the I-140 approval or pending receipt notice, the one that you're hoping to base the interfile on. But there could be complications. So for example, one, as I said, you always have to make sure that your date is current according to Table A. And then based on whether, you have children who are aging out and things like that, there might be reasons that you want to adjust based on one I-140 and not on the other. So I guess it's always, my advice would always be, if you have access to counsel, then, go for it.
Yes, absolutely. It just makes things easier for everybody and reduces chances for error as well. Just want to reiterate, we are live right now. So if you have any questions, our partner and attorney, Dia Matthews, is with us, and we're talking about interfiling. This discussion today is just for informational purposes. This does not create an attorney-client relationship. So shoot some questions our way. We do have a question from Maheshwara Rao Mudagala. He's asking us, if date is current in EB-3 and EB-2, do you suggest to interfile from EB-3 to EB-2? My priority date is December 11. I would imagine it's 2011. Downgrade was applied in EB-3 and I received EAD and AP, but no green card yet. What's your advice here?
Yeah, that's the typical situation. That's the typical scenario in which you would do the interfile, because, the EB-3 date was good. But what USCIS has declared is that they have more visas available in EB-2 and EB-1. So they want people to take advantage of EB-2 And so the interfile is a way of alerting USCIS to the fact that you have an EB-2 I-140 approved and that the priority date is now current. So makes it easier for them, if you put in the interfile request.
Right. All right, Maheshwar. I hope that answers your question. Okay, so you did answer this question. This was going to be my next question. Does one get a receipt notice after interfiling? Does one get that? I think you did answer some of that.
Yes, in a way. So the interfiling guidance is that if you have an approved I-140, right, approved EB-2 I-140, which you're using as the basis for your interfile, then you should send in a 485 form, 485J form. So the 485J is the job offer that we talked about earlier, right, from the employer. And so once you put in the 485J, you get the receipt notice for that. That might take some time. It's not, that it doesn't come in all that quickly, but you will get it. So at least you have some proof that the interfile request has been accepted. If you're interfiling based on a pending I-140 applicant petition, then you don't, technically speaking, you don't need to put in the 485J. So you might not get a receipt notice, but you should probably keep some form of confirmation, like a FedEx confirmation or something, that your interfile request has been sent.
Okay, that's good to know. Another question that I get asked all the time is, how soon can I expect the green card to come after sending the interfile request? I guess people have waited more than a decade for green cards to arrive, especially those from backlog countries. This seems like a very valid question.
That's a very good question, and I wish I knew the answer to that. So nobody can predict, right? It's USCIS is supposed to get through the cases in the order in which they were filed. First in, first out, etc. But we know that's not always the case. But I can say that from the cases, the interfiles that we had filed before this guidance came out, many of those cases were approved within a couple of months.
Okay, that's good to know.
There's not enough to speak to a pattern, but definitely some of them. And I think we had all the documentation. There was no complication, very straightforward cases, interfile cases. And those were approved probably within 2 months, 2 to 3 months.
Perfect. All right. What should an applicant be cautious about when they are, filing for or interfiling so that their chances for rejections are low?
So with interfile, there's no timeline prescribed, right? And USCIS has also said that this is something that they've adopted for this fiscal year because they expect the visa numbers to be available until September 2022, right? That's when the fiscal year, the USCIS fiscal year. So we don't know. I mean, they are not held to the standard that they have to, honor all these interfile requests by the end of the year. So, but I think there is definitely an intent. They do intend to get through these as much as possible. So,
right.
Yeah.
Okay. So, once a person who had, downgraded, say, in October of 2022, and now they're eligible to interfile, right? So what happens to the petition that was downgraded? What happens to that petition?
That petition, so that's the EB-3 petition.
Yeah.
Sometimes, and this was more, we would see this in the past, like if there's multiple I-140s approved for a person or an I-140 with a family-based petition, sometimes the USCIS would come back and ask you to withdraw one before they approve your green card based on the other, I-140 petition. And the reasoning was that they cannot have too many A files, green card files open at the same time, some, technicality.
Yeah.
But I don't see that happening now, with the interfiles that we already filed and which have been approved. USCIS just acted on the, the interfile request and they just approved the green card, no questions asked. So I think they've done away with this whole formality of withdrawing the other petition because, God knows, they really don't have the bandwidth right now to do all this.
Yeah.
So I don't think anything is going to happen to the, the other I-140, the EB-3. I think it'll just be once the green card is approved.
Okay. I guess, I also feel that USCIS has been under the scanner quite a lot since October 2020, first for the whole H-4EAD thing. And then, there was a lawsuit also on the whole green card backlog. So I guess USCIS is probably trying to make things easier for everybody.
Yeah, I think it also has something to do with the administration, the change of administration and the, the whole vibe, right?
Yes.
Coming out. So we know that there is definitely staffing challenges. We have people waiting on the EADs and advance paroles from October 2020, right? Some of them have still not. I think the majority of people got their EADs and advance paroles from that filing, but there are still people who are waiting. And when we place a service request, we just get this blanket response. Your case is in queue. We are unable to offer you a timeline. Please wait. Basically, a non-responsive response.
Yeah. Well, that's typical, isn't it? So another question that I have right now is, if I interfile now and get my 485 approved, all right, how long am I required to stay with my current employer? Is there a timeline?
So so it's two different things. You're talking about portability.
Yes.
Portability is one thing. So the whole AC-21 portability, you're talking about maybe giving up your age or whatever underlying status you had, and then using a green card to port. So with the anytime you use the EB-2 I-140, what you want to make sure is that your EB-2 sponsor, the petitioner that sponsored the EB-2 petition for you, and it's not necessary that you should be working for that petitioner right now, right? But that petitioner should be willing to give you that 485J to enclose with your interfile request.
Right.
Yeah.
Right. Okay. All right. We do have a question from the audience. Ranjan Kumar Sinha is asking us, does filing the interfile request with the I-485 supplement J restart the 180-day portability clock?
Yeah. So again, portability and interfile are two different things, as I said.
Yeah.
So interfile, basically, when you interfile, you need that EB-2 I-140 petition to still be open and supported by the EB-2 petitioner. Okay, so that's primarily what you're looking at when you put in an interfile request, because as I said, you need the 485J. Portability is a different thing. Portability, basically, you're asking about whether you can use your 485, the pending 485, to give up your your H-1B status or whatever you had, and use the EAD, I assume, right? So the requirement for that is that your I-140, the primary I-140, the EB-3 I-140 should be approved, and the 485 should be pending for at least 6 months, 180 days. That's the requirement for portability.
All right. See, this is exactly why one needs a guidance of a good attorney, someone to give you the right kind of counsel, because there's a lot of information available on the net, and it's easy to kind of, everybody wants to save money, but till the time you don't have a good guidance, I would always go with an attorney, right? Rather than complicating the case further.
Yeah. And that's, the other thing is, people think sometimes, it's very simple. Or the I-140, the interfile is just a cover letter and you give it, you send it to California, the designated address. But it's not. When we review an interfile request, we have to look at the entire file, see if the person has met all the requirements in terms of maintenance or status. Is the I-140 good? And then the other things like aging out of children, Child Status Protection Act, those kind of things. So it's never a question of just sending off a cover letter to USCIS. There's more that goes into it.
Absolutely. Harish has this question. And he's asking, in your opinion, is it advisable to stay in your spot? Could this be a trap by USCIS to make extra fees? A lot of people from October 2020 haven't received their adjustment of status. Some of them haven't received any of it.
Yeah. No, so it's not a trap. In fact, I think USCIS has kind of, made the common sense, decision. And they've said, okay, because when people were refiling adjustment applications, then they had to pay a fee. Yes. But with the interfile, there is no filing fee that USCIS gets. Maybe there is a professional attorney fee, but USCIS doesn't make any money. So there's no trap. It's just, they're asking us to help them do their job and make it easier.
Okay, all right. We are here to help USCIS. If that's making your job easier, it's making our jobs easier too. So Hardik's question is for you, Dia. What's special office address for interfile and supplement J submission? Is it different from usual service center? I think you just answered that a little while ago.
Yes, there is a designated address. It's a new address in, I think, Montclair, California for the interfiles. And they've also said if you previously, I mean, even before the guidance came out, as I said, some folks had sent an interfile request. So with those, if you already have an interfile request pending with the USCIS, then I think the guidance says don't send in a new, interfile request. But I think it might make sense to discuss it, because in some cases the files are in different locations. The EB-2 might be in one location, the EB-3 might be in another location. So there might be some value in putting in an interfile request, because this is a streamlined approach that they've given us. So
right, absolutely. And we're talking about the whole interfiling, but how does one find out? I think this is just going to summarize some of the talk that we are having today. How does one find out if they're eligible to interfile?
So again, to recap the main requirements, you would have an EB-3 petition approved, an EB-3 I-140 approved. You would have a 485 application, which is in process already. Doesn't matter whether it is 180 days or whatever. What's important is that the 485 should be filed and pending with USCIS. And you find out that your EB-2 date is faster, is current according to Table A of the visa bulletin. That's the situation where you would be requesting an interfile. You're eligible to request that USCIS approve the 485 based on the EB-2, the approved EB-2 I-140.
Yeah, I guess, this topic is so vast and the people have so many questions, also because there's this new guidance from USCIS about the whole interfile, right? We're in the last 4 minutes of our discussion right now. And just want to reiterate, we're live on LinkedIn, Facebook, and YouTube. If you have any questions, send them to us now or write to us, info@chuk.com. This discussion today is for informational purposes only. So this does not create any kind of attorney or client relationship. We'll be happy to help you. info@chuk.com. That's your best friend right now. Okay. So, we spoke about the service centers. Can people actually choose which center they can apply to? I mean, we are hearing a lot of stories about the Texas center. Some people are also calling it the black hole. So what do you have to say?
That's a great question. So I think that's one of the most, commonly raised questions these days. Can you make sure that my case doesn't go to Texas Service Center? And, honestly, we have no say in this matter. There's no control over, where your case goes, because filing locations are designated by USCIS based on the individual's place of residence. And when we send in a 485 application or even an I-140 concurrent with the 485 application, these go to the lockbox, the USCIS lockbox. And the purpose of the lockbox is really just to receive all these applications, and then USCIS assigns them to various service centers based on their caseload. So there is absolutely no way to, to circumvent this, and if your case goes to MSC or, some other location, then I guess great. But I think Texas is also trying to get through their backlog. So let's help them.
Yeah, there have been people who've been waiting for decision for over 13 months, Dia. Do you have any advice for them? They've had their petitions transferred to Texas Center, but they've been waiting 13 months and there's been no decision. What can they do?
Yeah. So if the case, you're talking about I-140 petitions, right? Yeah.
Yes,
so so EB-1 cases, EB-1 I-140 petitions obviously are not eligible for EB-1 C3. They are not eligible for premium processing at this time. So I think we have cases that we filed beginning of last year, which are still pending with USCIS. So there's, no way to expedite those. We just have to wait on USCIS. And then with the EB-2 and EB-3s, which have the premium processing option, you can avail of that. Otherwise, we are seeing, I think, timelines of over, 12 to 15 months for these I-140s.
Yeah, I could go on and on. There are a lot of questions pouring in right now, Dia, but time is short. We're in the last 60 seconds of our discussion. I want to thank you for taking out time and, discussing this, making, bringing your expertise to this topic, Dia. Thank you so much. And all of you who joined us today on our discussion, thank you for watching us live. If you have any questions, info@chuk.com. We will see you next week with probably a CPA. Whatever questions you have, shoot them to me, info@chuk.com. We'll see you next week. Stay safe and sound. Bye.